Okay, everyone, we're going to go ahead and get started. So this is Christy Wright. She's from the Office of Institutional Equity, Policies and not Policies and Procedures. That's what the presentation's about. But she's here to talk about Title IX and all the policies and procedures surrounding that. Just a quick announcement. We're going to go through special programming, go through legislation, but we will be breaking at 7:45. We will be going to the vigil, and then we will all be reconvening at 8:45. And I'll reiterate that as well here. Okay? Does that make sense? Perfect. All right, Christy.
Okay, can you guys hear me? So bear with me. I'm not wearing the right thing I don't have anywhere to put this, so I'm just gonna hold on to it and hope that I don't mess this all up too bad. So I'm Christy Wright. I'm the director of the Office of Institutional Equity. I'm also the Title IX coordinator for the institution and the ADA coordinator for the West Lafayette campus. And so I've got some slides to kind of walk through. I'll try to explain where we're at today and where I think that we might be headed in a little bit. We do have other staff within the Office of Institutional Equity, and I thought it'd be important to let you know who they are so that if you ever have contact with them or you need to reach out to somebody, you kind of know who they are and what their roles are and kind of the overview of our office. So the Office of Institutional Equity has three main components. I mentioned earlier that I'm the ADA coordinator, so I oversee ADA compliance for the institution. Any kind of accessibility concerns get reported to my office. We did have a senior associate director, Aubrey Abel. She has, for personal reasons, resigned her position, and so we're looking to see kind of structure-wise, like what the best structure for the office is, maybe kind of revamp some roles a little bit. Or if we don't do that, just refill that senior associate director role. She was also a deputy ADA. She was the director of care for a long time, so she was the director of the Center for Advocacy, Response, and Education. She came over to our office in January of last year as our associate director. She is in large part overseeing all of our outreach and resources supportive measure efforts and is doing that now with Maggie Wetzel. She's our new case manager investigator, so she's brand new in our office. It's a new position, currently funded for 1 year. But I'm actively trying to seek permanent funding for that position because we do have a large volume of incident reports that come into our office. We'll talk more about incident reports in a little bit, but those come in from mandatory reporters, but anybody can submit an incident report. You can submit it on behalf of yourself, you can submit it on behalf of a friend, faculty, staff, students, visitors, guests, general public can submit incident reports to our office. Which triggers outreach and resources, an invitation to come and speak to our office and learn about their options in terms of investigations or supportive measures. And so that's a large job. And having a person in our office whose sole responsibility is performing that function, I think is an essential function for our office, and that's what Maggie is fulfilling. She comes to us from the DRC. She worked in the Accommodated Testing Center, and she previously has years of case management experience outside of the university. And so I couldn't be happier or more excited about what I'm seeing out of her since she started in our office. I think she's going to be really exceptional in that role. Jake Amberger is a senior investigator in our office. Chris Parthen's the Title IX investigator, and Dawn Gross is an investigator. We use a dual investigator model. Tammy Patrick is also an investigator. So every investigation that we do has 2 investigators assigned to it. They're pulled mainly from those pools of individuals. We have investigators at the regional campuses as well that can help out, as well as outside investigators. And then Maria Pointer is our new administrative assistant. Some of the other areas, so I mentioned that we have the ADA component in the office. We also have oversight of faculty search and screen, so making sure that there's equal opportunity and equal access in the hiring process. And that is something that Tammy Patrick also oversees, all of that hiring. We don't have oversight of staff hiring, this is just faculty related. And then the third area of OIE, and one of the main areas is the harassment and discrimination Title IX work. So all of that incident report, outreach, resource functioning, any investigations, whether those are informal complaints, so those are more like mediations, or formal complaints, which are formal investigations that it's a disciplinary process, so can result in sanctions at the end. The main commitment from Purdue is to maintain that safe and positive environment, free from harassment, and to do the things that are listed on this slide. So recognizing and valuing the inherent worth and dignity of every person, fostering tolerance, sensitivity, understanding, and mutual respect, and encouraging each individual to strive to reach his or her own potential. And so these are the things that my office is working on a day-to-day basis. Because Purdue accepts even a penny of federal funding, we are obligated to comply with Title IX. So Title IX of the Education Amendments of 1972 prohibits discrimination on the basis of sex, including pregnancy and parental status, which I want to speak to in just a minute, in any federally funded education program or activity. Some people think that Title IX is focused on gender equity in sports or athletics. Some people think that it's only related to sexual assault on campus, but it really covers all of it. So it's the whole spectrum of any type of discrimination or harassment on the basis of gender or sex in the educational environment. It includes athletics, of course. It includes sexual assault on campus. That pregnancy and parental status is important. I think people don't realize that. And so in the context of pregnancy in Title IX, pregnancy is treated as a temporary disability. And so it has protections under the ADA as well. But my office can help students who are pregnant either with issues during their pregnancy, during childbirth, after childbirth, if there's a miscarriage, any of that kind of stuff that would impact their education. My office can help facilitate accommodations for them with their classes and keep them on track or get extensions of deadlines, incompletes in the classes until they're able to come back. In some cases, we've helped them transfer to a regional campus because that's closer to home for them, or switching to online courses. We have obligations to eliminate harassment, prevent recurrence, and address the effects. And so we're doing programming and education outreach and support, preventing recurrence. We track all of the incident reports that we receive. We maintain electronic databases and spreadsheets so that we can look for different trends on campus or maybe multiple reports with a specific individual. It may be that years down the road we get another report that name's familiar. We've got records on that we can look back to. And then that investigation arm comes in terms of preventing recurrence, so in terms of sanctioning or separating people from the institution either on a short-term or a long-term basis, depending on whether they've been found to have violated university policy or not. Addressing the effects of the discrimination comes in the form of those sanctions, either to make the environment more comfortable and safe for the impacted party, again, because the respondent is no longer affiliated with the institution, or through supportive measures. And so we'll talk a little bit later. I've got a couple slides on supportive measures, and we'll walk through what those are and how we can support students that way. We have two different processes, and I know that this is something that people find confusing, and so I think it's important for everyone to understand the role of the federal government in these regulations and driving what the policies and process and procedures are. And so not solely, but generally speaking, you can kind of track the changes in the Title IX regulations with different administrations in the federal government. So you had regulations under the Obama administration, and then that pendulum swung differently under the Trump administration, and we're currently waiting for new Title IX regs. So this summer, notice of proposed rulemaking was issued under the Biden administration. The comment period ended in early September. They're now in a process where they have to, they can group them, but they have to respond to every comment that they receive when they issue their final rulemaking. And so they're in the process right now of reviewing all of the comments that anybody worldwide has submitted on the regs, the draft regs, and then they will respond in category and then issue their regs and let us know when they're going to be effective. And so as I stand here today, I don't know what the new regulations are going to be. I've seen the draft, and there are things in there that would change some things, and so we're just waiting to see. The more time that passes in October, the closer we get to November, the more likely I think that it is that these are not going to go into effect in January. And if if you made me tell you right now when I think they're going to go into effect, I would say in August of 2023 for that next academic year. The Trump administration gave us a very short window of time to turn around new policies and procedures and practice, basically a 2.5-month window. And I think that we're going to not be in the same boat again, but I don't know. They could issue the regs tomorrow, and I would have to come back and tell you that I was completely wrong. So where we sit today is that we have the Title IX harassment policy. And this policy covers everything that the federal government says meets the definition of Title IX. And we have a set of procedures for resolving those. Prior to the Title IX harassment policy that went into effect on August 14th of 2020, we had the Equal Opportunity, Equal Access, and Affirmative Action policy and the Anti-Harassment policy. We didn't have a separate Title IX harassment policy, so any Title IX incidents were addressed under the Anti-Harassment policy. I will walk you through what the key differences are, but we still have those policies. We still have the Equal Opportunity, Equal Access, and Affirmative Action policy and the Anti-Harassment policy, and a set of procedures that govern how those are addressed, the complaint process, and then now we have a Title IX harassment policy and a set of procedures that apply to those. And so what are the main differences? So the Title IX harassment policy, it's jurisdictionally based. So the federal government restricted the definition of what constitutes a Title IX incident. So it has to occur on or after August 14th of 2020, on campus or on campus owned or controlled property, which would include, an event. So say an athletics team travels out of state and they're staying in a hotel, and that would be considered on campus for purposes of Title IX. And in the United States. So they very clearly said study abroad programs are no longer covered by Title IX. They said these are the only things that constitute Title IX matters, and these are the only things that universities have to address, right? So, but they gave us discretion and the ability to decide to address things beyond that. And then you had choices. You could address them under the Title IX harassment policy, or you could do, a separate process. We at Purdue thought that we should still cover things like sexual assault, relationship violence, and stalking that occurs off campus, right? So one of the choices could have been to say, well, it happened off campus, so it's not going to be covered by our policies, and we're not going to address that conduct. We said we think that we should address it, and we think that the policies and procedures that we had in place to address it before August 14th of 2020 were good, and that's the process that should apply to cover those things. And so that's why you have the anti-harassment policy and the Equal Opportunity, Equal Access, and Affirmative Action policy covering that off-campus conduct. There are also things like sexual exploitation that are covered by the anti-harassment policy that are not included in Title IX harassment. So Title IX harassment, when they changed the regs at the federal government level, they said it's only the things that are VAWA crimes, the Violence Against Women Act, and sexual exploitation is not one of them. And so we address that through our anti-harassment policy. The Title IX harassment policy and procedures calls for a 60-day investigation period, because that's what the federal government says the investigation period should be, 60 days. It ends with a live hearing with cross-examination. Both of the parties have to be in the same space. They don't have to be in the same physical space. So we do them remotely through WebEx, but they have to have their cameras on and they have to be able to see each other. They don't have to look at each other. They can minimize their window so that they don't have to look at the other party, but the other party has to be able to see them and how they answer questions. Witnesses also have to come to the hearing and be subjected to that cross-examination as well. That's required by the regulations. The anti-harassment policy and equal opportunity, equal access affirmative action policy, that culminates after a 45-day investigation period with an equity panel meeting. So that is a decision maker who convenes a panel of 3 members from the Advisory Committee on Equity. Those are faculty and staff members who are trained in our policies and procedures, who serve as advisors to the decision maker. I'm the decision maker in faculty and staff respondent cases. So I'll select, I have a panel meeting coming up soon. So I'll pick 3 members from that committee, screen them out for conflicts based on the college or the area or the department that they're in. And then they serve as advisors to me. So we have an equity panel meeting. It's around a conference room table. Both parties are invited to participate separately. They're never in the same room at the same time. They're able to share information about how it impacted them. We can ask them any clarifying questions, and we also meet with the investigators. the decision maker in the Title IX harassment policy is a hearing officer. Both of these processes will end with a written determination letter that will let both parties know whether there's been a policy violation, why, if there is one or not, and if there is one, what the sanction is. Sanctions can range anywhere from training or a letter of reprimand up through and including some sort of separation from the institution. So things like probation, probated suspension, or expulsion. Both processes have appeal processes built into them, so either party can appeal that determination. Title IX harassment then covers dating violence, domestic violence, retaliation, sexual assault, and then specifically breaks sexual assault into rape, fondling, incest, and statutory rape, stalking, and Title IX harassment. And those are, again, all as they're defined by the Violence Against Women Act. Title IX harassment then is essentially sexual harassment. So quid pro quo sexual harassment, which is I do this for you, you do this for me, or if you don't do this, then I'm not going to. So if you don't have sex with me, I'm not going to give you an A in the class. That's quid pro quo sexual harassment. Unwelcome conduct that's so severe, pervasive, and objectively offensive that it interferes with somebody's educational or work environment. So it has to be all three things. It has to be severe, pervasive, and objectively offensive. And then sexual assault, dating violence, domestic violence, and stalking constitute Title IX harassment. So if we have an investigation of sexual assault and there's a policy violation, by definition, it's also Title IX harassment because it's one of the delineated forms of Title IX harassment. Our anti-harassment policy and equal opportunity, equal access, and affirmative action policies are similar but slightly different. So instead of breaking it up into dating violence and domestic violence, we have relationship violence. We have retaliation as well. We have sexual violence. It's not broken up into those four categories, but it's a general definition of sexual violence. Sexual exploitation, so this is a difference. Stalking under both, and then sexual harassment. There's also racial harassment, general harassment, and then discrimination on any university recognized protected class. And the university recognizes protected classes broader than what the federal government requires. So how can we help in OIE? If you or someone you know is in imminent danger or harm, obviously call 911. Do not pass go. Call 911 and get them the help that they need. You can connect them to my office by calling our office. You can submit an incident report online, and I'll show you kind of where to go to do that. You can give them those resource cards that were passed out. So these are the Purdue Can Help resource cards that have information from my office, PUSH, PUPD, CAPS, and then the Dean of Students office and CARE. And I want to take a minute to kind of explain that. So in our process, parties are entitled to have a support person present, and that's complainants and respondents. The university will connect respondents with a support person from the Dean of Students office. So Julie Cox's team, I don't know if you all know Julie Cox, her team serves as support persons for respondents. So people who are accused of violating our policy, we will actively reach out and offer that as a support to them. We found for a long time that respondents would go through the process without any support person with them. So they won't tell their friends, they won't tell their family, and they're kind of going this process alone. And that's their prerogative if they want to do that. And we used to send out a letter basically saying, if you want a support person, you can reach out to Julie Cox's team. Now we affirmatively reach out and say, hey, I'm your support person if you want me to go. They don't have to respond to them, but at least they're not the one that has to make the first contact. We also then connect students who are complainants or impacted parties with CARE. So CARE staff members serve as support persons for impacted parties or complainants. And again, they don't have to use CARE as an advocate or a support person, but we want to affirmatively connect them with somebody who can do that for them. And so that information's on there. They can start wherever they want to start. If they want to start with my office, we're more than happy to meet with them and walk them through their options. We're the ones who administer the supportive measures, and so they can come directly to us. If they want to go to a confidential advocate first, I would direct them to CARE. We partner regularly with CARE. We have a great working relationship with them. I meet regularly every week with their director. They don't share information with us unless they have a signed release of information, so we're not going to get names and information that we don't otherwise have. But we do copy them on information from our office so that they can actively reach out to impacted parties to provide support for them. So you can connect them with CARE. They have 24-hour, 365-day-a-year support available. So they have I think they work with a call service that will determine whether it's a true emergency or whether it can wait till the next business day. But they can go with students to get SANE exams done at the hospital. If somebody wants to report to law enforcement and they want somebody to go with them, CARE can go with them, even if it's in the middle of the night. So they're really a great resource. They can also help students get protective orders through the court system. So we do mutual no contact directives through our office, but if they want to go through the court system and have a court order that prohibits that contact, and if it's violated, they can be arrested, that's something that CARE can help with. You can help connect them with PUPD or law enforcement. One point I want to make here is that my office doesn't report incidents to law enforcement. So privacy laws prohibit us from sharing that information, and we try to treat our matters as confidentially as possible. So coming to OIE and talking to our office about support resources or complaint options isn't going to throw you automatically into a legal process. And so those civil and criminal cases are completely separate from university processes. My process is an internal administrative process. If somebody wants to report to law enforcement, we can help them do that. There is a caveat, like we do have to report suspected child abuse and neglect. Anybody who's 18 or older in the state of Indiana has an obligation to report suspected child abuse or neglect to either law enforcement or child protective services, and the failure to do so is a Class B misdemeanor. So to the extent that you're over 18 and you learn about that, just be aware of that obligation. But that's really the only time that we report anything to law enforcement, that or if there's an imminent harm. So if somebody calls us and tells us that they're going to go do something to somebody right now, we're going to call the police so that that doesn't happen. And then encouraging the individual to seek medical attention or emotional support, so push and CAPS. You all are not mandatory reporters if you're students, but there are individuals at the university who are mandatory reporters. There were some changes with the last round of regulations from 2020 that restricted the class of people who are mandatory reporters. So essentially removing faculty members and RAs were the biggest changes. So academic advisors, faculty members, and RAs are no longer mandatory reporters unless they're a supervisor in success factors, then they are. So it's kind of, if they have supervisory authority over people, then they have the authority to take corrective action, and so then they meet that definition in Title IX of what a mandatory reporter is. So if somebody is a mandatory reporter, our best practices recommendation is that they tell people up front that they're a mandatory reporter so that they know that before they share information. And then if they don't want to talk anymore, then they would give them a resource card or a resource guide and connect them to a confidential source. So again, those confidential sources on campus are CARE, CAPS, and PUSH. If somebody shares information with you, providing support and resources, so the things that we've talked about tonight, listen without casting judgment. Recognizing that, there may be more to the story than what they've shared with you, so you don't know all of the facts, you haven't done an investigation, and we would recommend that you not try to resolve the matter on your own, but get it to people who are trained to deal with these things, whether it's CARE or law enforcement or my office. And then not promising confidentiality. If it's not something that 100% that you can guarantee that it can be confidential, then I wouldn't promise anybody that you can do that. So how to report an incident. This is a screenshot of the Title IX website, so purdue.edu/Title IX. There's some buttons on here that I'll show you. They're the same on the OIE webpage, and I'll show you a screenshot of that too. So you don't have to know whether the incident falls under the Title IX harassment policy or the anti-harassment policy to know which, submit an incident report button to click. It's going to go to the same form and it's going to come to me. So pick one of them. Doesn't matter which one you pick one of them. And so that's the button on the left-hand side, the middle button says request a complaint form. So one question we get a lot is, why aren't your complaint forms online? The reason is because it's complicated and knowing which process you fall under. And so we can tell you which complaint form you need real quickly. All I need to know is when did it happen, where did it happen, and who's involved. I don't need to know a lot of details. I don't need to do a long interview with you to get that information. But if you can tell me those 3 things, I can tell you which process you're in and give you the correct complaint form. The federal regulations for Title IX have mandatory dismissal provisions in them. So if somebody files an off-campus sexual assault complaint, for example, on a Title IX complaint form, I have to dismiss it. Now, in my letter, I'm going to tell them why I'm dismissing it, and I'm going to give them a link to the other complaint form. But my fear is that a student who got up enough courage to submit the complaint form in the first place and gets dismissed is going to say, well, forget it. I'm not going to go through this anymore. So we're trying to avoid that happening by asking people to just contact us, give us real brief information, and we'll get you the complaint form that you need. And then the last middle button on the right is to basically request an appointment with our office. So it's an email form that just asks you to say when you want to meet, and then we'll have usually Tammy or Maggie will reach out and say, when are you available? We'll meet with people in person or virtually, depending on whatever they want to do. We're here, we're back on campus. We have been for a long time. So we're over at Young Hall. We don't get near the foot traffic we used to get, but we're there every day. So if people want to meet in person and they're more comfortable doing that, great. I have seen a lot of students be more comfortable, or it's better for you to just do a virtual meeting because you don't have to cross campus to come to our office, and we're fine with that too. So, and you can have a support person join you in that meeting at any point. And then there's some other links on there for resources as well. This is the OIE homepage. And again, there were some questions last year about, a one-stop shop. It's hard when it's not the only thing that my office does. Like, we don't just do Title IX matters, right? We've got these 2 processes already, even within like sexual assault. Could be Title IX harassment, or it could be anti-harassment. But then there's all that other responsibility. So the ADA coordinator responsibility, the faculty search and screen responsibility. So we have been consulting with marketing and media about ways to streamline and change the website to make it more user-friendly. But again, those buttons are the same. So if you go to this, they're just on the left-hand side, those gold buttons. Submit an incident report, request a complaint form, meet with our office. The bottom button on the left-hand side is report an accessibility concern. So I know that's not the topic of tonight, but if you ever encounter something that's not working properly on campus, like a blue button for a door, or maybe they start construction somewhere and they've blocked the sidewalk, or we had a lot of trouble with the robots early on, blocking, just stopping in the middle of a sidewalk path and blocking access. You can report all of those to our office as well, and we'll address those. And that button, we'll pull up a form similar to the incident report form that asks for some information so that we can address that. There's also, I put an arrow at the top right hand to a link about support services. That'll get you information about CAPS and CARE and other on and off campus resources. After an incident report is submitted, it goes to my office. We open a case, and by a case, I don't mean an investigation. I just mean a case in our file management system. And we're going to send a message to the person who submitted the incident report if they give us their information saying, thank you for submitting this incident report. We will reach out to the impacted party. We're then going to send outreach to the impacted party. It's a standard letter that says, we've received information that you may have experienced an event that maybe endangered your safety, or there's a list of different things. And then we'll invite them to meet with our office. We'll attach a resource guide, give them information about CARE if that's appropriate, and then we'll track it. So usually the goal is within 2 days to do a follow-up outreach. So if we don't hear back the first time, we'll follow up with a second outreach. If we don't hear back after the second outreach, most often we're going to close the matter and just track it for our purposes. Often I like to call these puzzle pieces. So sometimes it's partial information. We don't have the respondent's name, or we don't have the location, or maybe we don't have the complainant's name. We still track that on our spreadsheet, and then maybe weeks, months, or a year later, we'll get another puzzle piece that we're able to connect and put together. So we do track them and watch what's going on. Sometimes we will require a meeting. Usually this is where the allegations include things like a weapon, choking, strangulation, something where we've seen in research that choking and strangulation oftentimes will escalate to something worse than that. If that's not bad enough, something worse. Or something that would be a broader campus safety concern. So not just these two individuals interpersonally acting, but a broader safety concern for the whole campus. That may cause us to meet with the impacted party, make them meet with us to talk about what's going on. Sometimes we'll meet with a respondent if we don't have an impacted party's name to put them on notice of the allegations. That's usually more frequent with faculty or staff respondents, not student respondents. And then, possibly following up, again, this is more HR related, but with the department. So maybe putting an employee on notice, giving them a letter of expectations. And then if the conduct continues, then they can go through an HR discipline process. Supportive measures are one of the biggest things that my office does. So these are non-disciplinary, non-punitive, individualized services that we are required to provide under Title IX. This is one of the more rewarding parts of my job to be able to provide, because as you can tell, it's not exactly the most positive subject matter. But this is a way to help people and give them some autonomy and control over what they want to see happen next. So this is not, these are offered to complainants and respondents with or without a formal complaint. So you don't have to file a formal complaint and go through an investigation to have supportive measures. And most often, there isn't a formal investigation ongoing with the supportive measures that we're providing. A lot of students want to have supportive measures that allow them to continue to operate and function on campus and continue with their education and just get back on track that way, and maybe including a no contact directive, which we'll talk about in a minute, just to allow them to know that they can go about campus and not have to worry about running into or talking to this other party that was involved in the incident. So these are some examples. This is not an exhaustive list of things, but just some examples. So connecting to counseling services, extensions of deadlines or other course-related adjustments. So somebody is sexually assaulted over the weekend and they have an exam on Monday, but they haven't been able to focus on studying, or they've been at the police station all weekend or at the hospital all weekend. We will reach out to their faculty members and ask that their exams be extended, or maybe extensions, leaves of absences, they want to go home for a week. We can make that happen. We can extend deadlines. Some students will do just a general message to all of their faculty members saying, we're not asking for anything specific at this time, but we just want you to know that they're working with our office and we might ask for something later. We've seen that be very effective because it just gets them primed as a faculty member for when that comes. We don't tell them what happened. We don't tell them the name of the other party involved. They're on kind of a need-to-know basis, whether they like it or not. I tell them they're not entitled to know that information. We've had faculty in the past who want the student to have to sit and meet with them and talk to them, and we tell them absolutely not. They're working with our office, we're vetting these, and so they don't have to do that. The goal is for us to be able to open the door for the students, so we get we get that door open for them so that they don't have to tell the faculty member what happened to them. But then all they have to do is work on rescheduling the exam. So we'll say, okay, the exam's not going to be tomorrow. Work with them on a date that works for you to take that exam in the future, and then we can step back in if needed. We can do changes in work or housing locations. We can do restricted directory access so that addresses don't show up, increase security or monitoring of certain areas. And then the biggest change with the 2020 regs was that they said that a mutual no contact directive is no longer considered a sanction. Prior to the reg change, if somebody wanted a no contact directive, they had to file an informal complaint and both parties had to agree to it. And so all it took was one party saying, I'm not agreeing to that. And we couldn't put it in place without a formal investigation. Now, if one party asks for a mutual no contact directive, we can put that in place as a supportive measure, and we're not doing an investigation, we're not looking into the facts around it, we're not making any decision or statement that we think the policy's been violated or not. What we're saying is these two students need to not interact with each other on campus. If they're in the same class, we'll contact their instructor and let them know that there's a no contact directive in place. We don't tell them why. And we ask that they not be put in the same group or have to work together. So they can be in the same physical space, but they can't interact with each other. Same thing with clubs. You can be in the same club, but you can't interact with each other at the club. Means direct or indirect communication. So you can't have your friends contact them on your behalf. In person, by email, by phone, by social media, by any contact. If a party violates a mutual no contact directive, they're violating a directive of a university official, so somebody from my office. And we would refer that to the Office of Student Rights and Responsibilities for Conduct. It's a ton of information. What questions do you all have for me? And I will just be totally transparent that I'm having eye surgery next week, so I can't read any one of your name tags. So I'll just point if you have a question and you want to ask a question.
Thank you so much for coming to speak to us today. My question had to do concerning Title IX changes being relatively rapid. How does your office ensure that students properly know the processes that are currently in place?
So we do a lot of these meetings. So we go around to different classes, lots of campuses or classes or organizations on campus will ask our office to come and speak. Lots of times we do them in partnership with CARE. So even this morning, we met with American Studies and did a co-presentation together about our office, our policies, and our procedures. So that's one way. All new students, so whether they're their first semester or they're a transfer student in, are required to do the Respect Boundaries training, which gives information on the current policies and procedures. Faculty and staff, if they're mandatory reporters, have that mandatory reporter training obligation. And then there's some new educational modules and things that are voluntary, so different organizations have been utilizing those in terms of assigning them to their membership and saying, we want you to complete this module. With those modules in particular, so if you're having like a club or an organization or a class or whatever, do it. The students can, or whoever takes it, it's not just students, can download a certificate of completion, so you can require that within your organization that they provide that in. Yes?
I was wondering if you had any idea what the Office of Institutional Equity plans to do to address the general mistrust on campus now that students have towards Title IX just due to recent events.
Right, so I mean, I think that things like this, right, getting out and talking to people directly is really the only way that people are going to understand what our process is. There's a lot of misinformation out there, and so I invite dialogue. If anybody has any feedback on the process and they want to meet with me individually or send me information about what they think is working well or not working well, I invite that. I think that that's really the only way that any kind of trust will continue or be rebuilt going forward. I don't have an easy answer, really. I mean, I don't. I think that just understanding the process, understanding, these policies and procedures and the processes have changed a lot, even in the time that I've been affiliated with the institution. So I started doing outside investigations for the institution back in 2015 or 2016, and the process has changed a lot in the time that I've been here. So it's always evolving and changing, and like I said, we're getting ready, we're waiting to see what changes will come going forward.
I had another question that sort of built off what Sydney said. So what are some of the unbiased checks in place at Purdue to ensure that Title IX policy is being adequately followed within their hearings and investigation?
Like I want to make sure I heard you. Unbiased checks that are in place, right? So, well, one is we do a dual investigator model. So, my staff, I have an open door policy with my staff, and they are free to disagree with each other, and they engage in debate about cases. And if one of them's doing something that the other doesn't like, I would expect that they would come and talk to me about it. Now, I haven't had anything happen, that's of the level that you're talking about, but I have had some disagreements about, should we interview this person, should we not interview this person? And they'll come to me and say, well, I think we should, and they think we shouldn't, and then I'll tell them, like, okay, well, this is what I think should happen. Parties are invited to have a support person present with them in all meetings. And so, that can be an advocate from CARE, it can be a friend, a family member. In the non-Title IX process, there are some limitations in that the support person can't be a witness in the case. But in the Title IX process, the regulations state that it can be anybody that they want it to be. In both processes, they can have lawyers. They don't have to have lawyers as their support people. And any one of those people can give feedback to anybody involved. So if something happens during the process that they think is wrong, I would hope that they would come and tell me or someone else that something has happened that they think is inappropriate. And that would go for those panel meetings too, so they can have a support person in the panel meeting with them. And then for the Title IX, we didn't get into all of the detail, but the Title IX process, the university is required to provide hearing advisors. So when these parties go to the live hearing with cross-examination, the party themselves have to do the direct examination of their own witnesses. So like if you were a complainant, and what's your name?
Erica.
And Erica was a witness that you called, you would actually be asking Erica questions during the hearing. And then when it came time to cross-examine Erica, if I was the respondent, my hearing advisor would do the cross-examination of you. So anything that's considered more kind of adversarial is done by the hearing advisors and not the parties directly, and that's regulation driven. And so, kind of lost my train of thought on that. So the point being that they're going to have a hearing advisor in that process who's going to be present as well, right? And so they're going to be there and be able to speak up or provide feedback later if something happens. They're not in that process alone. And in the Title IX process, we're required to provide them a hearing advisor at no cost if they don't have one of their own. So it can be anybody that they want it to be. It can be their friend, it can be a family member. We've had people use their, a father has been a hearing advisor, professors have been hearing advisors, people hire lawyers as their hearing advisors. But if they say, well, I don't have a hearing advisor, I don't know who I want to use, we will assign them a hearing advisor, which is an OIE investigator who is been kept apart from the case. So I have 4 investigators, 2 are assigned to investigate, the other 2 are on hold, on standby if either one of the parties needs a hearing advisor. So if they come to the hearing, if they tell us ahead of time or they come to the hearing and they don't have a hearing advisor, we are as an institution required to provide one to them at no charge. So those are things that I think are in place as checks and balances to try to help mitigate any of that happening. There's also review, so the investigators make a recommendation in their report, but it's not the final decision. The panel members, the equity panel members, are also advisors, so they're going to make a recommendation to the decision maker. There's not the equity panel members in the Title IX process, but there's a hearing officer who's making a decision. The parties get to see all of the evidence in both processes. They get to see all of the evidence that we've gathered now, and they get to see a full investigation report. So years ago, it used to be they got a preliminary investigation report to review that contained just a summary of the facts that we gathered and no analysis or conclusions. So they didn't see what the investigators were recommending. Now they get the whole report. So they see the facts as they've been gathered and the recommendation of the investigators, and they get all of the evidence we've gathered, even if it's not relied on in the investigation report. So they get to see all of that. The decision maker will issue a written determination letter, and then there's an appeal process. And then, not that I would hope that this would happen, but anybody can file a complaint with OCR at any time. So the Office of Civil Rights, Department of Education Office of Civil Rights. So that's always on the table. If they think that something has gone wrong in the process, they can go file with OCR, the EEOC, and the court system as well. Other questions? I know I've gone over by 16 minutes and 40 seconds. And I know you guys have a tight agenda tonight, so I'm happy to answer one or two more questions or head on out and let you get to your business if you'd rather do that. And really, my contact, that's my direct line. Hold on, that's my direct line and my direct email. So if you have anything that you want to send and you don't want to say in front of a group, you can send it to me directly. Yes?
So you said that for the respondent that you don't allow them to cross-examine directly, but how does that work if they choose not to have an advisor?
They can't not have a hearing advisor. The regulations require them to have a hearing advisor. Both parties have to have a hearing advisor. And it's not just the respondent, it's like the other party. So then like when the respondent calls their witnesses, the respondent will question them directly, and then the complainant's hearing advisor will do the cross-examination. So both parties, anything adverse is done by a hearing advisor. The regulations require there to be a hearing advisor there. We had a hearing where the party didn't show up to the hearing, and we still had to have a hearing advisor who did the cross-examination of parties and witnesses even without a party there to do it. So my investigators will prepare for the hearing whether they hear from the party or not, so that they're ready to go and do that questioning as if they had a party present. And they did it vigorously. So it was like the first time it had happened that way, and they were cross-examining like the investigator in the office that's their coworker. And I think that at first they were like, whoa, what are you doing? But they took it seriously, and they do it as if it was their client. They're not lawyers. I'm a lawyer, they're not lawyers. They did it as if it was their client, and they're vigorously questioning on their behalf. And so that's the way that I like to see it work, right? Like I want them to make their co-workers uncomfortable in that process and challenge them if they see things that they have questions about. I mean, that's the whole point of the hearing. So does that answer your question? Any other questions? Well, thank you for inviting me to come. I really do appreciate the opportunity, and I really do invite feedback or questions or further dialogue. So you all have those cards, and if you need more, we have them electronically too, so if you want them to distribute to whoever, let me know, and we can get you that information. Thank you.
Oh, okay. Where is he? If Mason Merkel would like to come to the front to be sworn in. All right, we'll give it a sec. All right, if you want to raise your right hand and repeat after me. I state your name.
I, Mason Merkel.
On this 12th day of October 2022.
12th day of October 2022.
Swear to abide by and uphold.
Swear to abide by and uphold.
The Constitution and the bylaws.
The Constitution and the bylaws.
Of the Purdue Student Government.
The Purdue Student Government.
I swear to conduct.
Swear to conduct.
All legislative business.
All legislative business.
With the utmost integrity.
With the utmost integrity.
And with the best interest of Purdue University.
And with the best interest of Purdue University.
And its student body.
And its student body.
As my main objectives. All right, congratulations.
Okay, and before we get started, if you're missing your name placard, I very much apologize. This has been a little bit of a chaotic session. But we have extra ones, so like if you do need one, like just come down and get one just on your own. But with that being said, hello and welcome at 6:52 p.m. I will now call this meeting to order. We will begin with proxy reports first. So if you are a proxy, please state your name and the senator you are proxying for at this time.
My name is Kathy Morales, and I am a proxy for Wisconsin at the Polytechnic Institute.
Perfect. Okay. Hearing no more proxies, we will now move into roll call by Secretary Friend.
Senator Ferguson.
Here.
Senator Mariani.
Here.
Senator Hampton.
Here.
Senator Terrell.
Here.
Senator Scudder.
Here.
Senator Mann. Senator Brown.
Here.
Senator Kirkendall.
Here.
Senator Merkel.
Here.
Senator Wheeler.
Here.
Senator Dodona.
Here.
Senator Bottini.
Here.
Senator Conrad. Senator Alexander.
Here.
Senator DeLucia Green.
Here.
Senator Ackerman.
Here.
Senator Askunis.
Here.
Senator Tishosik.
Here.
Senator Bowman.
Here.
Senator de Guzman.
Here.
Senator Kirsch. Senator Adam.
Here.
Senator De Silva.
Here.
Senator Robinson.
Here.
Senator Yax.
Here.
Senator Jane.
Here.
Okay, we will now state the land acknowledgement. Purdue student government acknowledges the traditional homelands of the indigenous people, which Purdue University is built upon. We honor and appreciate the Potawatomi, Delaware, Miami, and Shawnee people who are the original indigenous caretakers. We will now move into the Pledge of Purpose, so senators, please rise for the Pledge of Purpose. Okay. Our voice is to be... Okay, the minutes for the last meeting were distributed to all via SharePoint. Are there any corrections to the minutes at this time? Okay, seeing none, the minutes are approved as distributed. We will now move into executive reports. President Jensen has been working very hard on the vigil, so that's where he is at the moment, so we will see him shortly. But for me, the way that this session is going to work, it's very abnormal, but we're going to recognize a motion to recess around 7:40, 7:45, and then a couple of us do have cars, so we will carpool to the vigil, and then we will all convene back here at 8:45 p.m. The vigil should be over by then. What? What's going on?
It's not organized travel. We're not organizing travel.
Oh, just kidding. We're not doing that, but just in case, you might want to come to the front at some point in time. Okay. Chief of Staff Oregby, do you have any executive reports at this time?
Only reminder is just the vigil, which I think everyone has heard about. And Engagement has a Capture the Flag event happening at Croc Lawn tomorrow. Just check the Instagram. It's there.
Do I hear any other executive reports at this time? Yes.
Yeah, so the second edition of the Bluer Update's going to go out tomorrow at some point. So if you could get me any information you want on that by, say, midnight tonight, that would be awesome. But
I just wanted to let you know that all the people back here are court just to observe.
Perfect. Yes.
We're getting around the time of the year where everyone should be more seriously looking at their Senate duties and thinking about what they want to do for those. If you have any problem or have any issues with them, please reach out. I know we have some new senators, and if you're having concerns about completing them, please reach out to Izzy, Lily, or I.
Any other executive reports? All right. Seeing none, we will now move into committee reports, starting with IA.
So big thing from IA, past couple Senate sessions, my updates has been working on the standing rules. Those are going to the floor tonight, so very excited about that. Beyond that, I will start doing some research into giving some insight into possible election guidelines going into this election this year. And that's all from us.
Okay. Financial affairs.
We just approved our first small grant of the year, so that's pretty exciting. So barring the small kinks that have come from that, we're doing really well there, and we're looking forward to reviewing some more applications on Sunday.
Campus and student resource affairs.
Well, last week we had a table at the HEAM event. Hopefully you were all able to make it. We gave out over 400 coloring pages, so I hope people went home and colored their hearts out. No one really did what the intent was, but it's okay. It's okay. It worked out. Also, completely unrelated, but if anyone would like a mental health coloring page, there might be about 300 in the closet, give or take about 100. Probably give about 100. But I thought it was pretty successful for our first event. Very pleased. Thanks for all that helped. People that stopped by. So.
Perfect. University academic affairs.
So we're just trying to come up with legislation for attendance and for classes. We're still talking about that and how we can write legislation for that. And then I'm trying to maybe find a way to create a legislation for making the honors contract more than 2 weeks. There's more to that, and it's just in the beginning stages. So,
ad hoc committee reports.
Yeah, so Safer had our consent tea party last Thursday. It was really awesome. We did that with RHA. We had a lot of attendance. It was fantastic. We're going to do that again in the spring, which is good. We got a lot of interest based on the survey that was sent out to all the student body. Not the survey, the statement that was sent out to the student body. So we're sort of going to go through all those applicants and work a little bit more on some of the Title IX stuff that we were working on last year.
Great. Any other? Yes.
Yeah, Pride had our first quote-unquote official meeting this last Saturday over fall break, where we elected our committee chairs, myself as well as Claire Bowman, and we're working through a few initial projects.
Fantastic. Yes.
No major updates from the Disabled Committee, ad hoc committee. Shout out to Pro Temp Ferguson for kind of getting the names of the people from the interest forums, and I will be adding those individuals to our Slack as soon as possible.
Great. Any other committee reports at this time? All right. Seeing none, we will now move into informal discussion. Do I hear any informal discussion at this time? Okay. Seeing none, we will now move into old business. Do I hear any old business at this time? Yes, Senator Terrell.
A motion to bring up Bill 2223.
Second.
It has been properly moved and seconded to bring up Bill 2223, the PSG Small Grant Action Plan Update. This bill is amendable and debatable and requires a majority vote. We will start with discussion from the authors of the bill and then move into discussion from the floor. Is there any discussion at this time? Yes.
Point of order, it's not amendable.
That's right, it is not amendable. Now is there any discussion? Yes.
Yeah, I pretty much got everything out last week when we talked about this and voted on it previously. But as I said previously, the small grant program is something that we do every year, and it hasn't been updated really at all in our guidelines since 2020, despite there being some updates made to the general process. So this is really just taking those changes and putting them on paper to make sure we follow through and follow all the rules that we put in place for ourselves.
Perfect. Is there any other discussion at this time? Okay. Seeing none, we can move to a vote on Bill 2223 for the second time. So first, all those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? Okay. Also, if you guys could do the vote on the SharePoint as well, that would be very helpful. Bill 23. And if you don't have access to the SharePoint, that's okay. We can fix that at a later date. But as soon as I see some people look up, we can move on. Okay. Okay, so as of right now, the vote is 20 to 0, so Bill 2223 passes for the second time. So congratulations to everyone. Okay, do I hear any old business? Seeing none, we can now move into new business. Do I hear any new business? Yes.
I move to suspend the Senate standing rules.
Second. Yeah.
I can talk on the motion.
Go for it.
So as we mentioned in the Senate Slack, that in order to consider these nominations for these positions without having them go to caucus, the Senate standing rules need to be suspended for that to happen. I can answer, or Lily can answer any other questions that you all might have on that.
Yes.
Julia, I don't know where you are but there you are. What's the vote on this bill? And I'll yield like 2 minutes.
2/3 majority.
Okay, so at this time, Julia, I guess this is a question for you, does the new bill need to be called up at this time, or just?
This is a vote to suspend the rules.
Okay, got it. Okay, so all those in favor of suspending the rules, please raise your name placards. Okay, all those opposed, same sign. Okay, any abstentions? Okay. Seeing none, with a vote of 23 to 0, the motion passes to suspend the standing rules. Yes.
I motion to bring up Bill 2226.
Second.
Okay, it has been properly moved and seconded to bring up Bill 2226, the Cabinet Appointment of Executive Director of Communication, Colin Lee out. This bill is amendable and debatable and requires a majority vote. We will start with discussion from the authors of the bill and then move into discussion from the floor. So, Chief of Staff Rugby, would you like to start?
Yeah, I'd be happy to. So first, I'd like to apologize for how late in the semester we're bringing you this executive director bill or appointment. We just had some issues at the beginning with the original person that we had hoped on being our executive director. They weren't unable due to other. That being said, Colin is an incredible candidate for this position. Just looking through his application, it was very clear that he was a standout candidate. He has held a position as a marketing director of the swim club, where he had the opportunity to promote team events. He was responsible for doing live updates on the Instagram, specifically regarding a national swimming event, which you can imagine is probably quite time demanding. Additionally, he was able to increase their account reach by about 137%. So if numbers mean anything to you, there's that. And then additionally, he also has held the senior vice president role for the marketing and communications of Larson Leaders Academy. So in that position, he was able to, remain consistent and in regards to his social media presence, which I think is a really important quality to have. Furthermore, he was also able to, take track of scheduled as well as day of posts. So it's really important that we're able to be flexible regarding social media. Many times I've been able to reach out to Colin and ask him to, maybe make a post on the fly or change something about a post due to maybe some time or weather constraints. So he's been very flexible, and that's just another quality that I've been able to see through him and his experience here. Additionally, he's also a Larson Leaders Academy mentor, so that just goes to show that I have a lot of confidence in his ability to just kind of lead the committee, because I think that leadership regarding your committee as well as just mentorship is also an important quality. So as you can probably see, Colin is qualified through many of his experiences. For example, marketing director of Swim Club, VP of Larson Leaders, and then Larson Leaders Academy Mentor Program, as well as just his experiences working with us so far. I'll now pass it off to Colin to tell you a little bit about his own experiences.
So as the Senior Vice President of Marketing Communications for the Larson Leaders Academy, I sort of mentored the VPs of Marketing and VP of Communication come up with an advertising strategy to promote the various different types of professional events that we do host towards our target audience, which are students within the program. In addition to this role, I've been able to learn more about the Purdue branding guidelines and keeping them very consistent across the board, and some of the initiatives in terms of what I would want to put in place as the Executive Director of Communications is something that I have been working on recently. So the takeover, which is going to be called Takeover Tuesday, Takeover Tuesday, which is sort of supposed to engage more of the student to the leaders in PSG, as well as creating sort of an initiative to bring more awareness towards the Minority Months and Heritage Month. So as you've seen on the recent post of the Latino Heritage Month, there was information about work disparities as well as post-pandemic that's about that minority group. So just bringing more awareness, which I think is very important during this day and age, is something that I was really passionate in bringing towards the communications department in PSG. Thank you.
Perfect. Yes. Would anybody like to yield any time to press secretary? Yes.
I'll yield 3 minutes of my time to press secretary, Chris.
Awesome, thank you. I just want to echo Chief of Staff Oregby's support of Colin. He has done a great job so far and is on the official position of this role, and every time I've asked him to do something or whatever, he's been on it right away, and so I think he'll continue to do a great job.
Great. Do I hear any other discussion at this time? Okay. Seeing none, we can now move to a vote on Bill 2226. What? Oh, you're right. Sorry. Okay, we will now move to a vote on Bill 2226. All those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? Okay. You guys can all input your votes onto SharePoint now. Okay. With a vote of 23 to 0 to 0, Bill 2226 passes. So congratulations, Colin. Okay, do I hear any more new business? Yes, Senator Terrell.
A motion to bring up Bill 2227.
Second.
It has been properly moved and seconded to bring up Bill 2227, the Supreme Court appointment of Justice Jacob Pranger. This bill is amendable and debatable and requires a majority vote. We will start with discussion from the authors of the bill and then move into discussion from the floor. So, Chief Justice Kim, you want to start?
All right, so I had 2 justice positions available, and Jacob was a very easy choice for one of those 2 positions. He's been on court since about the middle of last year, and right away we knew that he was going to be a justice, whether it be the next available spot or sometime further in the future. But ever since Jacob joined, he's always been super, like a great participant in court and always provides valuable feedback and discussion, and is a very natural fit for the position. I think most of the people on court can agree. I definitely talked with a lot of the other justices on court, and they all agreed that he was a very natural pick for this position.
Do I hear any other discussion at this time? Okay. Pro Temp Dodona.
So what sort of traits do you believe it's important for a justice to have, and how do you possess them?
I'm testing right now. Is this working? I've never done this before. Can you tell? Just generally, with the most important trait I think a justice should have is being open-minded completely, because when you go in, like, there's people coming into court all the time, and they're Thank you. You're the best. There's people coming in with all kinds of grievances, different circumstances, and I think one thing that Robert has really brought up this semester is that circumstances mean basically everything whenever they come with us. You want to go in without any bias. You want to hear arguments completely, and then once everything is said and done, with all the evidence being presented, all the testimony, you want to make that choice. And also you want to have that open-mindedness towards the person who's bringing forth the case, and you also want to be open-minded towards what the other justices have to say, because we're not a hive mind. We've never been a hive mind. I'll tell you that. A lot of people have different opinions. People will want to do one thing, and they'll have their reasons for doing it. And just having that open-mindedness towards others and towards the people presenting their cases is really important. At least for me, I'd say that's definitely the most important trait.
Is there any other discussion at this time? Okay. Seeing none, we will now move to a vote on Bill 2227. All those in favor, please raise your name.
Point of order, he's got to go.
Oh my God. Sorry, Jacob. Okay, now we will move to a vote on Bill 2227. All those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? Okay, go ahead and put your vote onto SharePoint. Okay, with a vote of 23 to 0 to 0, Bill 2227 passes. Congratulations, Jacob. Okay, do I hear any new business? Yes, Pro Tem Dodona.
I move to bring up Bill 2228.
Second. It has been properly moved and seconded to bring up Bill 2228, the Supreme Court appointment of Justice George Francis. This bill is amendable and debatable and requires a majority vote. We will start with discussion from the authors of the bill and then move into discussion from the floor. Chief Justice Kim, would you like to start?
All right. So George joined court this year at the beginning of this semester, alongside a bunch of other clerks that we took on by the end of the summer. And we knew when we took a lot of these clerks on that we were looking for people to fill justice positions and looking for those characteristics. So in the first few court sessions, we really observed how all the clerks were prepared and asking questions in court, as well as very long and kind of annoying interview and application process. But after a lot of discussion and a lot of hard decisions and a lot of qualified applications and clerks for the position, we ultimately came upon the decision to choose George. I know for a fact that a lot of the other justices are very strongly in favor of George as a justice to fill the rest of our court. And I think George will be an amazing justice. He's shown a lot of leadership, a lot of interest in opportunities. He's always reached out to see if there's anything else he can do, any other opportunities that he can fulfill. And I think George has a lot of the good qualities that it takes to be a good justice.
Great. Do I hear any other discussion at this time? Pro Tem Ferguson.
Could you talk a little bit about your experiences and how that lends to being a successful justice?
So I just want to clarify, do you mean experiences in court or out of court?
Either is fine.
Okay, so in terms of out of court, I've been pretty involved on campus, and one thing that I've found is really important for court is just having a strong willingness to listen. And so through the other things I do, like I do tutoring with North End Community Center, I'm an ABA ambassador. A lot of what we do is learning to listen to everyone and seeing how sort of listening what they want, what they need, and seeing how that determines the outcomes. Whether it be tutoring, I mean, I tutor a pretty young child. A lot of the time she doesn't really want to be there. And it's just being willing to listen to her and understand all the parts of her argument and understand where we can sort of go with that. And I found that really important in court because a lot of the times you may look at a case and have a sort of opinion, but whenever you listen to the arguments, you listen to the cases, you listen to the evidence put forward, and sort of sway your opinion, sway you towards a different idea than you may have initially had. And in addition to this, I've been working as an AV ambassador for about 2 years now, and it's definitely been a really awesome experience being able to sort of guide people and sort of listen to them as they give their ideas, what they want to do, what they want out of the sort of AV experience. Being able to take those like experiences that I've gotten with listening to people and working with large groups of people, I think those experiences will be very applicable to the court that I'm joining.
Do I hear any other discussion at this time? Okay. George, I'm going to ask you to leave so our senators can vote on your appointment. Okay. We will now move to a vote on Bill 2228. All those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? Okay, go ahead and put those votes into SharePoint. Okay, with a vote of 23 to 0 to 0, Bill 2228 passes. Congratulations, George. Do I hear any other new business? Yes.
I move to reinstate the rules of the Purdue Student Senate.
Second.
Okay. That is a majority vote, so we can go ahead and vote. So all those in favor, please raise your name placards. Okay, all those opposed, same sign. Any abstention? Okay, the motion passes, so we have reinstated our standing rules. So now do I hear any other new business? Yes, Senator Terrell.
I motion to bring up Bill 2229.
Second.
It has been properly moved and seconded to bring up Bill 2229, amendment to the Senate standing rules of the Purdue Student Government. This bill is amendable and debatable and requires a majority vote. We will start with discussion from the authors of the bill and then move into discussion from the floor. Would anybody like to start? Yes.
So as I said in my update earlier, I has pretty much been working on this throughout the school year thus far. It actually started with the IA's committee last school year, hence so many names listed as authors. Some of them are actually graduated now. And if y'all saw the big message I sent out in the Slack earlier, you already know the main point, or points of change IA made to this. Those occurring in Article 2 about proper attire. That was mostly, if I recall, just making it so that open-toed shoes weren't explicitly not business formal, because a lot of women's shoes that are formal are open-toed. In case that bothers anybody, that was the main change in that section. A lot of the meaty stuff was in Article 4 about legislative procedure. Mainly, I don't know if I should go into every change during my update if people have specific questions. That was just about, in the past, authorship of a pro temp made it so it could skip committee. We put some more qualifications on that. We also changed a little bit about the timeline for when committees needed to get stuff to the pro temp. We also, another bigger change was happening how second amendments worked. Perhaps, or second readings. Thank you, Pro Temp Ferguson. Good. Pro Temp Dodona might want to talk on this more. I don't want to speak for her, but something she brought up was about having it so that amendments could occur on a second reading. Previously, this was not the case. There was some contention amongst that in IA. The compromise we came to was allowing for additional readings. So amendments could be made on any reading of any bill or resolution. However, in order for a bill that would normally require a second reading to go into effect, it would keep going through Senate until there was a Senate in which no amendments other than technical amendments were made, which is essentially how it works right now, except it puts that limit at 2. This extends that limit. We also changed Article 5 about debate, changing about how speaking time would work some. In the past, how it has worked, I don't know if it's typically kept track of. There is a maximum amount of time senators can speak on any given question. I don't know if that's something, Izzy, you keep track of this year. I don't think it was kept track of last year. So just getting rid of that because it's too difficult to track. But keeping it the fact that senators can only speak for a certain amount of time on any given question. That way it still gives new people to get into the conversation. We also extended the amount of time that a specific question can be talked about. We extended that from 30 minutes to 45 minutes just to allow for more time for conversation to happen. Because a pattern I've noticed in the past is usually when we hit that 30-minute limit and there's a vote, it kind of kills discussion a little bit, even if there's still valuable discussion being had. We usually don't hit the 30 minutes regardless, so that won't be too big of a change, hopefully. And in my experience, senators are more likely to vote to end discussion than to vote to continue it. So that's the reason for that change. And then we also made some minor changes in Article 6 about committee procedure, just for how frequently committees were required to meet. Explicitly it said once a month. We changed that to twice a month, though it could be more frequently at the discretion of the pro temps. As I'm sure you all know, most committees meet once a week, and we thought that was valuable for the functioning of Senate. We also changed how committees explicitly could hold their meetings. In the past, it was supposed to be we're following Robert's rules in every committee meeting. I don't believe this happened at most committees last year or this year. We allowed for that to be still the case if there was like a more heavily debated or more sensitive issue going into a committee. They could choose to do that, but that would be by committee's choice for each meeting. And we also gave some rules for giving them the opportunity to be virtual if that's easier for the committee. Those are the bigger changes. Again, technical, grammatical, spelling stuff all throughout. And if everyone has any questions about what I just said, me or the rest of IA would be more than happy to answer.
Do I hear any other discussion at this time? Pro Tem Ferguson?
I just want to propose a friendly amendment on the title page of the bill where it gives lists of when they've been updated, and just adding an update line, updated August 12th, 2022 by the Internal Affairs Standing Committee.
Okay, so do I hear a second for that? Okay.
It's
just the author has
friendly
to
amendment.
accept it?
All authors have to accept it. I have Lynn Silver on Zoom right now.
Okay, so is everyone who was an author all good? If anyone has any not good things to say, just raise your hand. Okay.
Lynn also gives a thumbs up.
Okay, perfect. Okay, so seems as though the friendly amendment has been enacted. Do I hear any other discussion at this time? Pro Tem Dodona?
Just to briefly mention what Senator Mariani said about the second readings, it was something that I brought up to IA that we've already sort of experienced this year, of frustration of like, we don't want to fail it because there's a small error, but we don't want to it's hard to vote for something that has that error in it. So the sentiment was to add an ability to amend on the second reading, but if amended on the second reading, that then requires an additional reading with no amendments to pass. I hope that sort of clarified. So if this if this isn't the second reading, but the next reading, I decided that I saw something that was substantial in this, I could change it, and then it would require an additional reading to formally pass. So in order to be enacted into our governing documents, and this only applies to legislation that has to do with impacting our governing documents, there must be a reading that has no amendments for it to be formally enacted. I hope that makes sense, everyone.
Senator Mariani?
And just to talk on that issue a little bit more, if these standing rules were to get voted upon, it would open up the possibility for like a piece of legislation to be at like every single Senate session. There is always, any single senator has the option to call for a vote to recommit any bill at any point in time. So if there is like a piece of legislation that is requiring many, many additional readings, a senator could say, let's just put this back to committee so they can handle it there, rather than continually doing it on the floor.
Do I hear any other discussion at this time? Okay. Seeing none, we can move to a vote on Bill 2229. So all those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? Okay, go ahead and put your vote into SharePoint, please. Okay, with a vote of 23 to 0, Bill 2229 passes. Congratulations to the Internal Affairs Committee. Okay, do I hear any new business? Yes.
I motion to bring up Bill 2230.
Second.
Perfect. It has been properly moved and seconded to bring up Bill 2230, the creation of PSG Ad Hoc Committee for the Black Boilermaker Experience Project. This bill is amendable and debatable and requires a majority vote. We will start with discussion from the author of the bill and then move into discussion from the floor. So,
Really quickly, before we get into discussion, can I propose a friendly amendment to change Shreya's name and spell it correctly and also add Ellie Dodona as a sponsor? And since I'm the author, that's okay, right?
Yep.
Dope. Okay, cool. So a little bit about this bill. I've been in the works right now of contacting the necessary parties, et cetera, but basically my initiative is to produce a documentary, hopefully by the end of this year, but if it needs to be extended, it can be. And I thought that with the creation of this ad hoc committee, it would be a great place for me to get all the necessary team members to come together to storyboard, plan for recording, things like that, and also allow people to have, be involved if they want to. My purpose of this is to amplify the voices of the Black Boilermakers on campus, which I clearly expressed if you read the bill. But if you guys, sorry, that was probably rude. I didn't mean to be rude. But if you have any questions right now, please feel free to ask them. Or if you want me to clarify anything, I would love to.
Do I hear any discussion at this time? Yes.
I think this is awesome. I just have one friendly amendment. The date at the bottom is 2020 to 2021. I propose making that 2022 to 2023.
Do you accept?
Yes, I'm in favor of that.
Perfect.
Great job.
Perfect. Do I hear any other discussion at this time? Okay. If there is no other discussion, we can go ahead and move to a vote on Bill 2230. So all those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? All right, go ahead and put your vote into SharePoint, please. Okay, with a vote of 23 to 0, Bill 2230 passes. Congratulations, Senator Robinson and James and Dodona. Sorry. Okay, do I hear any other new business? Yes, Senator Terrell.
I motion to bring up Resolution 2231.
Second.
It has been properly moved and seconded to bring up Resolution 2231, the SWANA bill. This resolution is amendable and debatable and requires a majority vote. We will start with discussion from the authors of the resolution and then move into discussion from the floor. Yes.
All right, well, right off the bat, I need to make a friendly amendment because me and Shreya worked hard to write this, so hard, in fact, we forgot to actually give it a title. It's not even a bill. So my friendly amendment is to change the name to SWANA Resolution in support of the addition of a SWANA demographic category.
Perfect. You're both in agreement. Perfect.
All right, well, now that it has a title. This was formed, well, the idea of this came from a meeting of the SWANA group that was formed. So Miriam is president of that. It doesn't even show her as a sponsor up there, but she is. So we met with her after that meeting, got boba, it was a good time. And she brought up the fact that like a big discussion of that meeting was the fact that there was no SWANA demographic. So it's really hard to prove not only the population numbers, but also to let those people have that form of their identity like expressed if there isn't even a category allowed. So for example, a lot of people have to pick, a lot of people that identify as being from a SWANA region feel like they need to pick categories around that, so Asian, African, sometimes like Indian, and according to that committee, it's just not a true representation. They feel the need to have to justify that, especially if they are with other groups that like are culturally identified. So we just wrote this in works with her to hopefully get the university to have a little bit more openness in the demographics, so everyone feels like they can pick something that they personally identify with.
Perfect. Yes.
I just want to stress how incredibly important it is for those numbers to exist because that allows them then to have representation of their culture on campus, which they have currently been denied because they don't have the numbers to prove it because they have to click Asian or they have to click African and they're told to go find their own culture within someone else's culture, which just doesn't work for them. So it's incredibly, incredibly important that they're able to pick what they identify with and what they feel represents them the best.
Do I hear any other discussion at this time? Would somebody like to yield some time to Treasurer Wiseman? Yes.
I give 2 minutes of my time to Treasurer Wiseman.
Thank you. I want to say I think this is a great bill. Just like when I read through it the first time, I had questions I wanted to bring up, or just points. I'll do them all just on my one speaking instance. The first, would it be possible to add and spell out what the SWANA acronym stands for in the bill? I think that would kind of add to the robustness of it because I had to Google it. And then I just had kind of, again, a question when reading it. For the first whereas clause, I thought it says conduct a survey. I don't know if there's if the people this is sending to will know what that means. I just thought that was kind of vague by a survey. So I just didn't know if there was something more to that.
Senator Terrell.
Yeah, so by conduct a survey, the reason we put that is because adding a demographic for SWANA, and I'll friendly amend that in a minute, it's because that would only apply to students that are applying to Purdue, that are like doing the application and all of that. So that doesn't give us any way to basically gauge how many SWANA students are already here. That way their voices can already be heard. I didn't want to make it too specific because there's a lot of rules over what you can send out via survey. So I was kind of leaving that. I'm hoping that this will start a conversation and then maybe future resolutions that are properly titled will help spur it along. So hopefully if they had any questions about that, they would reach out. I would like to think, because I didn't want to, I just was worried about making it more specific due to HIPAA and all that everyone has to abide by.
Mm-hmm. Senator Jane.
Yeah, the main point of this was just to show SWANA students that we know they exist, and it's the survey is just so that the university acknowledges that they are here and on campus they need to be represented. That's why it's not super specific.
Yes.
All right, and then I'd like to offer a second friendly amendment to the first whereas clause. So where it says conduct a survey with the new SWANA option, after SWANA in quotations, we will spell out Southwest Asia, North Africa, close quotation, not quotation.
Parentheses. Yeah. Senator Jane, do you agree?
Yes.
Okay, great. Okay. Senator Mariani?
Similar question in the vein of Treasurer Wiseman, because ideally this would be an option present on all future Purdue surveys. Why was that wording not taken as opposed, or why was like one single survey chosen instead of all future surveys?
Senator Jane?
We need the numbers first. Like, we don't even know. Just getting like a rough estimate and then working from there is like a good way to start this project.
Any other discussion at this time? Okay. Seeing none, we can move to a vote on Resolution 2231. All those in favor, please raise your name placards. All those opposed, same sign. Any abstentions? Okay. And then when you put this into SharePoint, make sure you're clicking resolution and not bill. Okay, with a vote of 23 to 0 to 0, Bill 2231 passes. Congratulations. Okay, do I hear any other new business? Seeing none, we can move into announcements. So first I would like to start, congratulations to you guys all. We really did kind of crank this one out, but so there will be no reconvening after the vigil, so please stay as long as you would like. Do I hear any other announcements at this time? Yes.
Next week, court is going to be preparing for Know Your Rights Week, so we're going to be watching some movies and eating pizza while putting together our stuff that we're giving out. So if you would like to participate in that, just reach out to me on Slack. Thank you.
Any other announcements? Yes, Senator Terrell.
I know this isn't like super applicable to anyone at the moment, but Purdue, the College of Ed student the College of Ed Student Council is really excited because we have found someone in Lafayette to partner with to be able to design t-shirts and then like get them sold for, it's not going to cost us anything. It's just a really good deal. So we are in the process of designing those shirts. So if anyone has an idea, your grandma's a teacher, your mom's a teacher, you're alum, you secretly want to change into education, I can't blame you. We're very open to ideas. It's really exciting, so I know you all want to buy a College of Ed shirt for Christmas. Like, you're welcome, I'm letting you know now. But it's just really exciting. The College of Ed as a whole is just really excited for the opportunity.
Perfect. Any other announcements at this time? Okay, seeing none, I think we will just move over the snaps to next time, unless someone has a very desperate snap they'd like to get out. I see your face. Do you have one you're holding back? Go for it.
I would just like to give a Senate snap to IA for getting the standing rules done. That was a lot of work, a lot of discussion. Both IA of this year and IA of last year. Thank you to everybody.
Fantastic. Okay. The chair would recognize a motion to adjourn. Yes.
Madam Chair, I move to adjourn.
Second.
Okay, it has been properly motioned and seconded to adjourn the meeting. It's not amendable, it's not debatable, requires a 2/3 vote. All in favor say aye. Aye. Any abstentions, any opposition? Meeting is adjourned. Thank you, everyone.
Make sure that you have people in it from Senate and you're going to the vigil.